Okay, we're going to read the California Code of Civil Procedure. We are in Part 3 of Special Proceedings of a Civil Nature, Preliminary Provisions. It's how we'll begin in Section 1063. Then Title 1 is of Writs of Review, Mandate, and Prohibition. And really, Chapter 1, 2, and 3 are writ of review, writ of mandate, and writ of provision. Chapter 4 is writs of review, mandate, and prohibition may issue and be heard at chambers. Chapter 5 is rules and practice and appeals. Title 3 of summary proceedings. So what that means is it's about summary proceedings. And Chapter 1 is confession of judgment without action. Chapter 2 is submitting a controversy without action. Chapter 2.5 is judicial arbitration. Chapter 4 is Chapter 3, but there's a Chapter 4, summary proceedings for obtaining possession of real property in certain cases. Chapter 5, COVID-19 Tenant Relief Act. Chapter 6, COVID-19 Rental Housing Recovery Act. Title 4, about the enforcement of liens. Chapter 1 is liens in general. Chapter 2.5 is oil and gas liens, certain liens and priorities for wages and salaries and consumer debts. Chapter 4, certain liens upon animals. Chapter 5, liens on aircraft. Title 5 of contempts, which means about contempts. Title 7, eminent domain law. Chapter 1, general provisions. Chapter 2, principles of construction definitions. Article 1, construction. Article 2, words and phrases defined. Chapter 3, the right to take. Article 1, general limitations on exercise of power of eminent domain. Article 2, rights included in grant of eminent domain authority. Future use is Article 4. 4 is substitute condemnation. Article 5 is excess condemnation. Article 6 is condemnation for compatible use. Article 7 is condemnation for more necessary public use. Chapter 4, pre-condemnation activities. Article 1, preliminary location survey and tests. Article 2, resolution of necessity. Article 3, resolution consenting to eminent domain proceeding by quasi-public entity. Chapter 5, commencing a proceeding. Article 1, jurisdiction and venue. Article 2, commencement of proceeding generally. Article 3, parties, joinder of property. Article 4, pleadings. Article 5, objections to right to take. Article 6, settlement offers and alternative dispute resolution. Chapter 6, deposit and withdrawal, probable compensation, possession prior to judgment. Article 1, deposit of probate compensation. Article 2, withdrawal of deposit. Article 3, possession prior to judgment. Chapter 7, discovery, exchange of valuation data. Article 1, discovery. Article 2, exchange of valuation data. Chapter 8, provisions or procedures for determining right to take and compensation. Article 1, general provisions. Article 2, contesting right to take. Article 3, procedures relating to determination of compensation. Chapter 9, compensation. Article 1 through 8 are in order: general provisions, date of valuation, compensation for improvements, measure of compensation for property taken, compensation for injury to remainder, compensation for loss of goodwill, miscellaneous provisions, remediation of hazardous materials on property to be acquired by school districts. Chapter 10, dividend interest. Article 1, general provisions, leases, encumbrances, and future interests. Just quickly going through Article 1 through Article 4, dividend interest. And Article 11, post-judgment procedure, includes Chapter 11, post-judgment procedure, includes Article 1 through Article 8. So this is another important section. Article 1, payment of judgment, final order of condemnation, deposit and withdrawal of award, possession after judgment, interest, proration of property taxes, abandonment, litigation expenses and damages upon dismissal or defeat of right to take, and costs. Chapter 12, arbitration of compensation and acquisitions of property for public use. So do not tell me there's an entire title. There is an entire title about eminent domain law that they snuck in here. So keep on going. Next title is titled Change of Names. That's Title 8. Title 9 is arbitration. Title 9, and within arbitration, there's 5 chapters. So 1 is the general provisions, 2 is the enforcement of arbitration agreements, 3 is conduct of arbitration proceedings, 4 is enforcement of the award, which is 2 articles within it: confirmation, correction, or vacation of the award, limitation of time. And Chapter 5 is general provisions relating to judicial proceedings. Article 1, petitions and responses. Article 2, venue, jurisdiction, and costs. Article 3, appeals. Title 9.1 is arbitration and medical practice. 9.2 is Title 9.2 is public construction and contract arbitration. Article 9.3 is arbitration and conciliation of international commercial disputes. I'm just going to skip through that. It's really long. Chapter 6 is still part of that. Title 9.4 is real estate contract arbitration. Title 9.5, arbitration of firefighter and law enforcement officer labor disputes. Title 10 is unclaimed property. That could be worth reading. Chapter 1, general provisions. Article 1, definitions. Article 2, purpose and scope. Chapter 2, receipt of expenditure of funds. Article 1, deposit of unclaimed property. Article 2, appropriation. Article 3, payment of claims. Chapter 3 is payment of claims. General is the first article. Refund of erroneous receipts is the second, and claims is the third. Under Chapter 4, management of unclaimed property, there's Article 1 through 4, general provisions, powers of the controller, sale or disposition of property, disposition of proceeds of sale or lease. Chapter 5, issue proceedings. Issue proceedings on, this is Article 1, issue proceedings on unclaimed property. 2, issue by notice and publication. 3, issue proceedings in decedent's estates. 4, permanent issue. Chapter 6, disposition of unclaimed property. Article 1, estates of deceased persons. Article 2, abandoned property. Chapter 7, unclaimed property law. Article 1 through 7 reads short title definitions and application. 2, escheat of unclaimed personal property. 3, identification of escheated property. 4, payment of claims. 5, administration of unclaimed property. 6, compliance and enforcement. 7, miscellaneous. Then there's Chapter 8, property in custody of federal officers, agencies, and departments. Title 11 is money judgments of other jurisdictions. Chapter 1, sister state money judgments. Chapter 2, foreign country money judgments. Chapter 3, tribal court civil money judgment act. Title 11.6 is civil action mediation. Title 11.7, recovery of preferences and exempt property and an assignment for the benefit of creditors. Title 12 is tribunal injunctions, and Title 13 is inspection warrants. So if I had to explain what matters the most out of this, because there's a lot here, I'd have to say there was something about pleadings. There was something about discovery. I don't know if that's overall or if that's just that particular section. There was stuff about like alternative dispute resolution, arbitration, dispositive pretrial motions and procedures. I feel like okay, but we didn't get into trial, right? But we got into some post-trial. Like rights to appeal, I suppose. So let me just also say that money judgments would be important, but it's from other jurisdictions, so a little less often would that occur. Unclaimed property is important to like banking, but I don't think you're going to have a cause of action about it. Again, labor disputes, like that happens before they come consult an attorney. Real estate contract arbitration, kind of the same thing. they might have consulted an attorney, and now the attorney has to go there and figure out what's going on in the like the rules of arbitration. So the whole Title IX about arbitration, and medical malpractice, public construction, contract arbitration, arbitration and conciliation of international commercial disputes, like that's all important, but it's when it comes up, you now know where to go for it. I don't know what change of names is, so I'm just going to read that. This is Title 8, and it's a lot longer than I thought it would be. It's got a little in there about really just like the parties changing their names, including businesses, and changing the petitioner's name. There's a certain procedure for it. They might ask for a birth certificate. So applications for change of names must be determined by the superior courts. That's how it begins. All applications for change of names shall be made to the superior court of the county where the person whose name is proposed to be changed resides, except as specified in subdivision E or G, either A, by petition signed by a person, if the person is under the age of 18, by one of the person's parents, by a guardian, as specified in E, if both parents are deceased and there's no guardian of the person, then by some near relative of the friend or person, and that's provided in the family code. So this is like its own proceeding, and isn't like talking about one that's already commenced. This is just its own name change thing. And they've stuffed some things in here like the unclaimed property, right? Post-judgment procedure, that's Chapter 11. But Chapter 11 of what? Eminent domain law. Okay, so eminent domain law is here. And unless if it comes up, read Section 1230 through, oh my God, it's really long, to 1273. Someone wants to change their name, go to 1275. Arbitration, 1280. We might try to record that, but it's really long. It's 1280 through 1299. That doesn't sound long, but there's a million little subsections. So the writs of review, mandate, and prohibition, that's asking the court to do something, and we don't really do that a lot. The rules of practice and appeals is one worth talking about, and same as summary proceedings, enforcement of liens, perfect, contempt, and that's really what is important here, is the top couple sections. How long is writ of review? Okay, so these writ sections aren't very long. Might as well read them. kidding. I mean, it's not that long. Yeah. May attend for that purpose and may thereon give judgment, either affirming or annulling or modifying the proceedings below. 1076. A copy of the judgment signed by the clerk must be transmitted to the inferior tribunal, board, or officer having custody of the record or proceedings certified up. 1077. A copy of the judgment signed by the clerk entered upon or attached to the writ and returned constitute a judgment roll. So this is available for limited civil cases and misdemeanors or infractions. Which I mean, it's obviously available for an unlimited civil case, but and like felonies, but I'm just kind of saying it's not just that. Okay, so the writ of mandate is next. Yeah, that sounds super auspicious, but it wasn't me. This is. All right. So, what's going on here? The law specifically enjoins as a duty resulting from office, trust, or station to compel the admission of a party to use an enjoyment of a right or office and blah blah entitled from which the party is unlawfully precluded by the inferior tribunal, corporation, board, or person. The appellate division of any superior court may grant a writ of mandate directed to the superior court in a limited civil case or in a misdemeanor or infraction case. Where the appellate division grants a writ of mandate directed upon the superior court is inferior tribunal for purposes of this chapter. We're going back to that again. Class of misdemeanors and limited civil cases. So I don't know if maybe it is intentionally excluding unlimited civil cases and felonies. Notwithstanding this chapter, this is 1085.5. In any action or proceeding to attack, set aside, void, or annul the activity of the Director of Agriculture. We'll do that in accordance with something else. And then the writ must be issued in all cases where there is not a plain, speedy, and adequate remedy in the ordinary course of law. It must be issued upon the verified petition of the party beneficially interested. The writ may be either alternative or peremptory. The alternative writ must command the party to whom it is directed immediately after the receipt of the writ or to some other specified time to do the act required to be performed or to show cause before the court at a time and place or thereafter specified by court order why he has not done so. The peremptory writ must be in a similar form except that the words requiring the party to show cause why he has not done as commanded must be omitted. 1088, when an application to the court has been made without notice to the adverse party and the writ is allowed, the alternative must be first issued. But if the application is upon due notice and the writ is allowed, the peremptory may be issued in the first instance with the alternative writ and also with any notice of the intention to apply for the writ. There must be served on each person against whom the writ is sought a copy of the petition. The notice of the application, when given, must be at least 10 days. The writ cannot be granted by default. The case must be heard by the court whether the adverse party appears or not. So we got to 1088.5 and we stopped talking. has been requested pursuant to Section 11523 of the Government Code or otherwise, and has not been filed with the petition, the party upon whom the petition has been served, including any real property and interest, shall answer or otherwise respond within 30 days following receipt of the copy of the record. 1090. If return be made, which raises a question as to the matter of fact essential to the determination of the motion and affecting the substantial rights of the parties, and upon the opposed truth of the allegation of which the application for the writ is based, the court may, in its discretion, order the question to be tried before a jury and postpone the argument until such trial can be held, and the verdict certified to the court. The question to be tried will be distinctly stated in the order for trial, and the county must be designated in which the same shall be had. The order may also direct the jury to assess any damages which the applicant may have sustained in case they find for them on a trial. The applicant is not precluded by the return of any valid objection to the sufficiency that may countervail if by proof either in direct denial or by way of avoidance. 1092, the motion for new trial must be made in the court in which the issue of fact is tried. 1093, if no notice of a motion for a new trial be given, or if given, the motion be denied, the clerk within 5 days of rendition of the verdict of the denial of the motion must transmit to the court in which the application of the writ is pending a certified copy of the verdict attached to the order of trial. After which either party may bring on the argument of the application upon reasonable notice to the adverse party. 1094, if no return be made, the case may be heard on the papers of the applicant. If the return raises only questions of law or puts in issue immaterial statements not affecting the substantial rights of the parties, the court must proceed to hear or fix a day for hearing the argument of the case. If a petition for a writ of mandate filed pursuant to 1088.5 presents no triable issue of fact or is based solely on an administrative record, the matter may be determined by the court by notice motion of any party for judgment on the peremptory writ. 1094.5. This is kind of long. A. So. Okay, here we are. Where the writ is issued for the purpose of inquiring into the validity of any final administrative order. I don't know where she is. This is such a long section. Geez, I didn't realize what this was. I thought it was, writ of mandamus, and yeah. This is like, it sounds like it's very common, which I don't really understand, because a writ or order of mandamus is a court order that requires a public authority or a statutory body to constitutionally perform a task which they are obligated to do. Yeah, but statutory body, public authority or statutory body, I guess that's a little bit more broad than just the court. So that might be why it actually sounds relevant. And I initially thought it wasn't. Okay, so I recorded that. Writ of prohibition. This is my last chance to understand what we're talking about. So let's see if we can. I mean, this is short. To 18, done. It's okay, this isn't a long section. Writ of prohibition, 1102. The writ of prohibition arrests the proceeding of any tribunal, corporation, board, or person exercising judicial functions when such proceedings are without or in excess of the jurisdiction of such tribunal, corporation, board, person. 1103. A writ of prohibition may be issued by any court to an inferior tribunal or to a corporation, board, or person in the cases where there is not a plain, speedy, and adequate remedy in the ordinary course of law. It is issued upon the verified petition of a person beneficially interested. B, the appellate division of the Superior Court may grant a writ of prohibition directed to the Superior Court in a limited civil case or in a misdemeanor or infraction case. Where the appellate division grants a writ of prohibition directed to the Superior Court is an inferior tribunal for purposes of this chapter. 1104. The writ must be either alternative or peremptory. The alternative writ must command the party to whom it is directed to desist or refrain from further proceedings in the action or matter specified therein until the further order of the court from which it is issued, and to show cause before such court at a time and place then or thereafter specified by the court order why such party should not be absolutely restrained from any further proceedings in such matter. Action or matter. The peremptory writ must be in a similar form, except that the words requiring the party to show cause why he should not be absolutely restrained must be omitted. 1105. The provisions of the preceding chapter, except for the first 4 sections thereof, apply to this proceeding. Great. Moving backwards to Chapter 4, writs of review, mandate, and prohibition may issue and be heard at chambers. 1107. When an application is filed for the issuance of any prerogative writ, the application shall be accompanied by proof of service of a copy thereof upon the respondent and the real property and interest named in such application. The provisions of Chapter 5, commencing with Section 1010 of Title 14 of Part 2, shall apply to the service of the application. However, when a writ of mandate is sought pursuant to the provisions of Section 1088.5, the action may be filed and served in the manner as an ordinary action under Part 2, commencing with Section 305, where the real party in respondent's interest is a board or commission. The service shall be made upon the presiding officer, or upon the secretary, or upon the majority of the members of the board or commission. Within 5 days after service and filing of the application, the real property and interest or the respondent or both may serve upon the applicant and file with the court points and authorities in opposition to granting the writ. The court in which the application is filed, in its discretion and for good cause, may grant the application ex parte without notice or service of the application as herein provided. The provisions of this section shall not be applicable to applications for the writ of habeas corpus or to applications for writs of review of the Industrial Accident or Public Utilities Commissions. 1108, writs of review, mandate, and prohibition issued by the Supreme Court, a court of appeal, or a superior court may, in the discretion of the court issuing the writ, be made returnable and a hearing thereon be had at any time. This again is writs of review, mandate, and prohibition may issue and be heard at chambers. The last chapter in the writs of review, mandamus, and prohibition is 5 rules of practice and appeals. 1109, except as otherwise provided in this chapter, the provisions of Part 2 of the Code are applicable to and constitute the rules of practice in the proceedings mentioned in this title. 1110, the provisions of Part 2 of this Code relative to new trials and appeals, except insofar as they are inconsistent with the provisions of this title, apply to the proceedings mentioned in this title. 1110A, if an appeal be taken from an order or judgment directing the issuance of a writ of mandate commanding a party to deliver water or for irrigation purposes, such appeal shall not stay the operation of the order, judgment, or writ as to the delivery of such water, but upon water must, until the final determination of said appeal, be delivered as commanded by the writ, provided that if any expense is necessary to be incurred by the defendant in connection with water supply with the land to be irrigated, said defendant shall not be obliged to furnish water unless the plaintiff shall provide a bond in such sum as the court may fix, condition that in the event of the judgment being reversed, plaintiff will pay defendant the amount of the expense so incurred, not exceeding the amount of said bond. That's the section, rules and practice of appeals. It means nothing to me. So, what does matter, I guess, the provisions of Part 2 of the Code are applicable to and constitute the rules of practice and proceedings mentioned here. The provisions of Part 2 of the Code relative to new trials and appeals, except insofar as they are inconsistent with the provisions of this title, apply here. And then there's like 2 specific appeals. Oh, okay. So the first one was about a room mandate commanding a party to deliver water for irrigation. I don't know why, but there's actually a 1110B. If an appeal be taken from an order or judgment granting a writ of mandate, the court granting the writ or the appellate court may direct that the appeal shall not operate as a stay of execution if it is satisfied upon a showing made by the petitioner that he will suffer irreparable damage in his business or profession if the execution is stayed. So, like, that's the type of language I'm expecting to hear. That other stuff, I don't know how it got here. Okay, so Title 3 is summary of proceedings, and confession of judgment without action, submitting a controversy without action, judicial arbitration, summary proceedings for obtaining possession of real property in certain cases. That's going to be important, but the Tenant Relief Act and the for COVID-19 Rental Housing Recovery Act, hopefully that's worked its way out of, I mean, it hasn't, it's still relevant, but you just have to determine if it's relevant. All right, so for summary proceedings, let's see just how long. Okay, this is only one section. Confession of judgment without action is 1132A. A judgment by confession is unenforceable and may not be entered in any superior court. B, the section does not apply to a judgment by confession obtained or entered before January 1 of 2023. What is that? Submitting a controversy without action. Chapter 2. 1138. Parties to a question in difference which might be the subject of civil action, may, without action, agree upon a case containing the facts upon which the controversy depends, and present a submission of the same to any court which would have jurisdiction if an action had been brought. But it must appear by affidavit that the controversy is real and the proceedings in good faith to determine the rights of the parties. The court must thereupon hear and determine the case, and render judgment thereon, as if an action were depending. Judgment must be entered as in other cases, but without cost for any proceeding prior to the trial. The case, the submission, and a copy of the judgment constitute a judgment roll. I'm writing down 1138. It sounds like you can get a judgment from the court if, like, the plaintiff and the defendant agree that they want one. Important for me presently. 1139, judgment must be entered in all other cases, but without cost for any proceeding prior to the trial. The case, the submission, and a copy of the judgment constitute the judgment roll. And 1140, the judgment may be enforced in the same manner as if it had been rendered an action of the same jurisdictional classification in the same court and is in the same manner subject to appeal. All right. Moving on to chapter 2.5, judicial arbitration. This is a bit longer, so I'll let my friend read if we can. She just stopped talking. Thanks. Let's read this. Judicial arbitration. upon any of the following. And the following were 1, the stipulation of the parties to an earlier arbitration hearing. 2, the written request of all plaintiffs subject to the motion by a defendant for good cause shown to delay the arbitration hearing. 3, an order of the court if the parties have stipulated where the court has ordered under section 1141.24 coming up that discovery other than that permitted under chapter 18 commencing with section 2034.010 of title 4 part 4 will be permitted after the arbitration award is rendered. So going back, actually no need to go back. Yeah, 24 is in here. This is cases ordered to arbitration subsequent to 1141.11. Just put it together. No discovery other than that permitted by Chapter 18 commencing with Section 2034.010 Title 4 Part 4 is permissible after an arbitration award except by stipulation of the parties or by leave of the court upon it showing good cause. So I was at 1141.17a, submission of an action to arbitration pursuant to this chapter shall not suspend the running of the time periods specified in Chapter 1.5, commencing with Section 583.110 of Title 8 of Part 2, except as provided. Pursuant to that looks bad. Except as provided. I lost my spot. So A, submissions of an action to arbitration pursuant to this chapter shall not suspend the running of time periods specified in Chapter 1.5, commencing with Section 583.110 of Title 8 of Part 2, except as provided in this section period. Part B. That looks hideous. Part B. If an action is or remains submitted to arbitration pursuant to this chapter for more than 4 years and 6 months after the plaintiff has filed an action, then the time beginning on the date 4 years and 6 months after the plaintiff has filed the action and ending on the date on which request for de novo trial is filed with Section 1141.20 coming up shall not be included in computing the 5-year period specified in 583.310. 1141.18 after I get my water for where's part C? What is that? All right, B is the Judicial Council rules shall provide for the compensation, if any, of arbitrators. Compensation for arbitrators may not be less than $150 per case or $150 per day, whichever is greater. A superior court may set a higher level of compensation for that court. Arbitrators may waive compensation in whole or in part. No compensation shall be paid before the filing of an award by the arbitrator or before the settlement of the case by the parties. C, in cases submitted to arbitration under Section 1141.11 or 1141.12, an arbitrator shall be assigned within 30 days from the time of the submission to arbitration. Any party, D, may request the disqualification of the arbitrator selected for his or her case on grounds and by the procedure specified in Section 170.1 or 170.6, a request for disqualification of an arbitrator on grounds specified in section 170.6 shall be made within 5 days of the naming of the arbitrator. The arbitrator shall disqualify himself or herself upon demand of any party to the arbitration made before the conclusion of the arbitration proceedings on any of the grounds specified in section 1071.1. I'm sorry, 170.1. But you don't really remember reading that. Oh my gosh, I can share my screen. Share. Whoa, that's so cool. Oh, I can't see it anymore though. You can see it. Okay, now it's bigger. I already read 1141.17. That's why I got so confused. We were talking about how much they can be paid. Okay. We're talking about being disqualified. 1141.19, arbitrators approved pursuant to this chapter shall have the powers necessary to perform duties pursuant to this chapter as prescribed by the Judicial Council. 1141.19.5, in any arbitration proceeding under this chapter, no party may require the production of evidence specified in subsection A, section 3295 of the Civil Code at the arbitration unless the court enters an order permitting pretrial discovery of that evidence pursuant to subsection C of section 3295 of the Civil Code. 1141.20. A, an arbitration award shall be final unless a request for de novo trial or a request for dismissal in the form required by the Judicial Council is filed within 60 days after the date the arbitrator files the award with the court. B, any party may elect to have a de novo trial by court or jury, both as to law and facts. Such trial shall be calendared insofar as possible, so that the trial shall be given the same place on the active list as it had prior to arbitration, or shall receive civil priority on the next setting calendar. Right? 1141.21 A1. If the judgment upon the trial de novo is not more favorable in either the amount of damages awarded or the type of relief granted for the party electing the trial de novo, then the arbitration award, the court shall order that party to pay the following non-refundable costs and fees, unless the court finds in writing and upon motion that the imposition of these costs and fees would create such a substantial economic hardship as not to be in the interest of justice. A, to the court, the compensation actually paid to the arbitrator less any amount paid pursuant to subparagraph B. B, to the other party or parties, all costs specified in section 1033.5, comma, and the party electing the trial de novo shall not recover his or her costs. C, to the other party or parties, the reasonable cost of the services of expert witnesses who are not regular employees of any party actually incurred to or reasonably necessary in the preparation of trial of case. D, the other party or parties, the compensation paid by the other party or parties to the arbitrator pursuant to subsection B of section 1141.28. Yet to come. 2, under 1141.21, the costs and fees other than compensation of the arbitrator shall include only those incurred from the time of election of the trial de novo. B, if the party electing for a trial de novo has proceeded in the action in forma pauperis and has failed to obtain a more favorable judgment, the costs and fees under subparagraphs B and C of paragraph 1 of the section A shall be imposed only as an offset against any damages awarded in favor of that party. C, if the party electing the trial de novo has proceeded in the action in forma pauperis and has failed to obtain a more favorable judgment, the costs under paragraph A of subsection 1 of subdivision A shall be imposed only to the extent that there remains a sufficient amount in the judgment after the amount offset under subdivision B has been deducted from the judgment. So, 1141.20. Where do I write this down? Here? This has to do with post arbitration trial de novo penalties if outcome is less favorable, whatever, something like that. Where was I? I guess 1141.22. The Judicial Council rules shall specify the grounds upon which the arbitrator or the court or both may correct, modify, or vacate an award. 1142.23. The arbitration award shall be in writing, signed by the arbitrator, and filed with the court in which action is pending. If there is no request for a de novo trial or a request for dismissal in the form required by the Judicial Council and the award is not vacated, the award shall be entered in the judgment book in the amount of the award. Such award shall have the same force and effect as a judgment in any civil action or proceeding, except that it is not subject to appeal, and it may not be attacked or set aside except as provided by Section 473, 1286.2, or the Judicial Council Rule. 1141.24. In cases ordered to arbitration pursuant to Section 1141.11, no discovery other than that permitted by Chapter 18, commencing with Section 2034.10 of of Title 4 of Part 4 is permissible after an arbitration award, except by stipulation of the parties or by leave of the court upon a showing of good cause. 1141.25. Any reference to the arbitration proceedings or arbitration award during any subsequent trial shall constitute an irregularity in the proceedings of the trial for the purposes of Section 657. 1142.26. Nothing in this act shall prohibit an arbitration award in excess of the amount in controversy as specified in Section 1141.11. No party electing a trial de novo after such award shall be subject to the provisions of 1142.21 if the judgment upon the trial de novo is in excess of the amount in controversy as specified in Section 1141.11. 1141.27. This chapter shall apply to any civil action otherwise within the scope of the chapter in which a party to the action is a public agency or public entity. 1141.28. All administrative costs of arbitration, including compensation of arbitrators, shall be paid for by the court in which the arbitration costs are incurred, except as otherwise provided in subsection B and in section 1141.21. B. The actual cost of compensation of arbitrators in any proceeding which would not otherwise be subject to the provisions of the chapter, but in which arbitration is conducted pursuant to the chapter solely because of the stipulation of the parties, shall be paid for in equal shares by the parties if the imposition of the cost would create such a substantial economic hardship for any party as not to be in the interest of justice as determined by the arbitrator. That party's share of costs shall be paid for by the court in which the arbitration costs are incurred. The determination as to substantial economic hardship may be reviewed by the court. 1141.30. This chapter shall not be construed in derogation of chapter or Title 9, commencing with Section 1280 of Part 3, and to that extent, this chapter and that title, other than Section 1280.1, are mutually exclusive and independent of each other. 1141.31. The provisions of the chapter shall become operative in 1979, except that the Judicial Council shall adopt the arbitration rules for practice and procedures on and before later in that year. I'm going to go back and give you chapter 4. Oh my god, I literally found this. There you go. Right there. Shall what? Apparently, I can't use this wave. Dang it. Shall what? What? Shall service of 3 days notice to quit upon a person or persons in possession be entitled to restitution of possession of the demised premises under this chapter. For purposes of the subdivision, a person who commits or maintains a public nuisance as described in section 3482.8 of the Civil Code or commits an offense prescribed in subsection C of section 3485 of the Civil Code or subsection C of section 3482 further the purpose of that offense shall be deemed to have committed nuisance upon the premises. 5. I feel like these what section are we in? All right, we first talked about don't do forcible entry, and what that looks like. And I think what we're talking about is circumstances when one, they have greater rights, and what type of notice is required based on what is this hereto qualified and now acting, or therefore to be qualified and act assigning or subletting or committing waste on this? I feel like these are for cause reasons to evict a tenant, but because we're talking about nuisance, and before that we were talking about conditions and covenants of the lease or pay the stipulated rent. The case may be, and save the lease from forfeiture. So we're talking about violated conditions. It sounds like you need to give them an opportunity to cure if they, violated signing and subletting. It sounds like. Okay, so these sound like just cause evictions, but let's go on to 5. When the tenant gives written notice as provided in section, it's not really just cause. What it looks like it. Okay, so when a tenant gives written notice as provided in section 1946, we know that section of the Civil Code of the tenant's intention to terminate the hiring of the real property or makes a written offer to surrender, which is accepted in writing by the landlord, but fails to deliver possession at the time specified in that written notice without permission of the landlord or the successor in estate of the landlord, if applicable, as used in this section. COVID-19 rental debt has the same meaning as the defined in 1179.02. Tenant includes any person who hires real property except for those persons whose occupancy is described in subsection B of section 1940 of the Civil Code. And 7, this section shall remain in effect until February 1, 2025, and as of the date repealed. 1162 is the one that really sticks out at me. In cases of commercial real property is 1161.1, but 1162 I was talking about. The clerk shall allow access to limited civil case records under this chapter, including the court file index and registered actions only as follows: to the party in the action, including the party's attorney, blah, blah. Okay. So let's go back to 1161 and see if we can get the girl to read it, because it's a really long bunch of stuff and I have to clean something up. these are tenants, right? And yeah. How did we get to this? Real estate. Horrible. Okay. So I'm going to guess here, like this has to do with my own lease. And this is my only way of like validating that I think I understand why we stopped, took a like detour into violence and the penal code and all that, is that like I could change my own locks or leave early if I was a victim of domestic violence. So I'm going to guess that all that and like the health, um, like care provider and all that has to do with demonstrating like evidence that I've been involved in domestic abuse. So now we're back to tenancy. All right. So I'm not seeing anything above that I missed here from like starting the commercial section when I walked away. How many days? 3 days notice to quit. Yeah, that was in the residential section. Okay, so here's the commercial real property after default and payment, right? Tenant shall retain the right of possession, like after trial, if the tenant was less than the amount due 5 days of the effective date of the judgment. No, but was reasonably estimated, the tenant shall retain the right of possession if the tenant pays the landlord within 5 days of the effective date of the judgment, the amount previously tendered if it had not been previously accepted. The difference between the amount tendered and the amount determined by the court to be due and 3 other sums as ordered by the court. So this is after trial. Doesn't really say how long a notice you need to give, but identified by notice of the amount claimed is not in fact correct. So we started with that. There's like a dispute about how much is due. If the landlord accepts the partial payment of rent, like there's a possibility that he's acquiesced. No, he's entitled to recover the difference between the amount demanded in the notice and the payment actually received. And this shall be specified in the complaint. If the landlord keeps the partial payment, the landlord's acceptance of partial payment is evidence only of that payment without waiver of any rights or defenses of the parties. So like I thought I heard something different. Does not constitute any waiver of rights, including the right the landlord may have to recover possession. Commercial real property defined for the purposes of this section. Let's just see if it mobile homes, okay. Means all real property in the state except dwelling units made subject to Chapter 2, blah, blah, Division of the Civil Code. Mobile homes is defined in 798.3 of the Civil Code, or recreational vehicles as defined in Section 799.24 of the Civil Code. So that means like boats, especially if it's in like a marina that isn't intended to be livable. All right, so in purposes of this section, there's a presumption affecting the burden of proof that the amount of the rent claimed or tendered is reasonably estimated in relation to the amount determined to be due upon the trial or other judicial determination of that issue. The amount claimed or tendered was no more than 20% more or less than the amount determined to be due. Okay, furnishing, reasonableness, whatever. The clerk shall allow access to limited civil case records to like an attorney or names of at least one plaintiff and one defendant, address of the premises, including the apartment, resident of the premises who provides the clerk with the name of one of the parties, shows proof of residency to a person by order of the court, which may be granted ex parte on showing of good cause, except as provided in G to any person or order of the court if judgment is. So this is like who the clerk can give stuff to, like not very important. Except as provided in G to any other person 60 days after the completion of the judgment against all defendants has been entered within 60 days of the filing of and blah. All right, GI, if the case, I'm guessing like if the property is encumbered by a mortgage and maybe the mortgage cares about like maybe the mortgage is in arrears and they actually have a reason to care about the payment by the commercial tenant. I think we're in commercial tenant unless we shifted. I know we're in limited civil cases. This section shall not be construed to prohibit the court from issuing an order that bars access to the record in the action filed under this chapter if the parties to the action so stipulate for purposes of section cause means. Right. It's weird, the gathering of newsworthy facts of a person pursuant to the evidence code 1070. I don't gathering of evidence to by a party to an unlawful detainer action solely for the purpose of something else. Right. That's why I'm just getting confused. Like, why would they say newsworthy facts? It is the intent of the legislature that a simple procedure be established to request ex parte. What? Ex parte. Order described in D, paragraph 1 of subdivision A. So now we're at letter C, the filing of a case so restricted. The clerk may mail a notice to the defendant named in the action. The notice shall be mailed at the address provided in the complaint. The notice shall contain a statement that an unlawful detainer complaint eviction actions filed naming the party as a defendant and access to the court file will be delayed for 60 days except to a party and attorney of one of the parties or any other person who provides the clerk like name of somebody, plaintiff or defendant in the action, live in the premises. The notice shall also contain a statement that access to court index, register of action, or other records is not permitted until 60 days after the complaint is filed, except pursuant to an order. Upon the showing of good cause for access, the notice shall contain on its face the following information: the name and telephone number of the County Bar Association, lawyer referral service in short, and then the following statement about lawyer referral service, how they're funded, their purpose for legal services to low-income persons in the county. The following statement for a notice set out pursuant to the section between October 31, 2022, important COVID-19 relief. Go get rental assistance. Doesn't matter if you're an immigrant. Notwithstanding any other law, the court shall charge an additional fee of $15 appearance by the plaintiff for filing a first appearance by the plaintiff. This fee shall be added to the uniform filing fee. This section does not apply to a case that seeks to terminate a mobile home park tenancy if the statement of the character of the proceeding and the caption of the complaint clearly indicates that the complaint seeks termination of the mobile home park tenancy. This section does not alter any provision of the evidence code. So then there's some COVID-19 rental debt. And again, like the clerk shall allow access to the civil case records, right? So like the party is a resident, another resident, a person by order of the court, which may grant an ex parte on the showing of good cause. So, another notice, judicial council forms for this purpose. Defining good cause again. Giving legislative intent. Now, for purposes of this section, now we're going to move through domestic violence and assume that it is what I was talking about. All right. What's all this? Documentation from a qualified third party. Okay, and this is just how it ought to be presented, probably from a form like a judicial council form. The documentation will be signed by the person, like a counselor. That's where we got to health practitioner, perpetration of abuse and blah, blah. And so they were talking about, they just got into a landlord shall not terminate tenancy or fail to renew one based on an action of abuse or violence against a tenant, the tenant's immediate family member, or the tenant's household member, if the landlord has received documentation evidencing abuse or violence against the tenant's immediate family member, or tenant's household member. That's where we left off. Because the landlord can't terminate, and then the landlord can if they live together. It occurs to me that this is entirely too long to be read tonight, and we're already at 2 hours and 37 minutes in an attempt to do so. We'll be here another very long time. Or should I just let it run? I can let it run until it stops. But